My name is Renata Okafor-Diaz, and I am a mechanical engineer who has spent most of her adult life designing things nobody else had thought to design yet. First as a junior engineer at a mid-sized industrial automation company in Pittsburgh, and now as the founder of a small IP licensing operation that, as of last quarter, clears roughly $175 million in aggregate portfolio valuation. I want to tell you how I got there, but I want to tell it slowly because the fast version, the version implied by a headline, makes it sound like a straight line from betrayal to triumph, and it wasn't. It was 11 years of unglamorous work, most of it done alone, on a whiteboard in the back corner of a coffee shop in Bloomfield that I am, to this day, embarrassingly loyal to. I should start with my brother Teo, because you can't understand what happened to my first patent without understanding what our family had already decided about the two of us long before either of us became adults. Teo is 3 years older than me, and for most of our childhood, he was the son my parents understood. He was social, physically confident, good at the kinds of things that photograph well, sports, easy charm with adults, the natural instinct to fill a room. I was the opposite kind of child, the one who took apart the toaster at 9 years old not out of mischief, but out of genuine need to understand the mechanism, who spent birthday money on a soldering iron at 13, who my mother, Marisol, still describes, not unkindly but not quite fondly either, as the quiet one who was always in her own world. My father, Kwame, worked as a civil engineer for the city, and I think some part of him recognized something of himself in me. The specific joy of understanding how load-bearing structures actually hold weight, but he was never a man who expressed that recognition directly, and so for most of my childhood, my interests registered in our household as a curiosity rather than a gift. Teo, meanwhile, struggled in ways that were less visible, but I understand now with the distance of adulthood, considerably more serious than mine. He was diagnosed with a learning disability late, in 8th grade, after years of teachers writing him off as unmotivated rather than recognizing what was actually a significant processing disorder, and by the time anyone actually helped him, he had already internalized a story about himself, that he was the disappointing one, the one who needed extra help, the one who would always be catching up. My parents responded to that story the way many parents do, by overcorrecting, hard, in his direction, for the rest of both our childhoods. Every family resource that could plausibly be allocated toward leveling the playing field for Teo got allocated that way, quietly, consistently, without much conversation about what it meant for the child, who wasn't struggling. I don't say this bitterly. I say it because I think it's the actual mechanism, the real reason for what happened later, and understanding the mechanism matters more than being angry at the people caught inside it. By the time I was 26, I had been working for 4 years as a junior to mid-level mechanical engineer at a company called Brannigan Fluid Systems, designing components for industrial fluid handling, valves, seals, flow regulation systems, the unglamorous machinery that keeps factories and refineries running without anyone outside the industry ever thinking about it. I was good at my job, well regarded by my direct supervisor, a patient, exacting man named Walter Huang who had, over those 4 years, become the closest thing I had to a professional mentor. But the real center of my life during those years wasn't my day job. It was a notebook. I had been sketching on nights and weekends for almost 2 years, a design for a self-regulating valve mechanism, a genuinely novel approach to pressure modulation in high-viscosity fluid systems that solved a problem I'd noticed at Brannigan that nobody there had actually tried to solve, mostly because the existing solution, while inefficient, was good enough, and nobody had the appetite for the R&D investment to improve on it. I worked the design out slowly on my own time, filling most of a spiral notebook with sketches and calculations, occasionally running early-stage prototypes past Walter informally, off the record, because I trusted his eye even though I wasn't ready to bring the idea to Brannigan's formal IP process yet. I wanted it fully mine before I brought it to anyone with the power to claim a piece of it. I had, by 26, saved enough from 4 years of a modest engineer's salary and aggressive frugality to cover the provisional patent filing fees myself, which I understood, from months of research, was the critical first step, the thing that would establish priority and protect the idea while I refined it enough for a full utility patent application. I want to be honest about what that notebook actually meant to me because I think it's the emotional center of everything that follows. I had grown up as the child whose interests were tolerated rather than celebrated. That notebook was the first thing in my adult life that was entirely, unambiguously mine. Not something I'd been steered toward, not something anyone else had suggested I try, just an idea I'd had, alone, at my kitchen table, that I'd built into something real through nothing but my own persistence. Around the same time, Teo, then 29, was arrested and charged in connection with a business dispute that had escalated badly, a partnership he'd entered into with a childhood friend that soured over accusations of financial mismanagement, accusations that were, as far as I understood them then and understand them now, seriously overblown but not entirely baseless either. Teo had genuinely made some careless decisions with shared funds, though nothing that should have risen to the level of the criminal charges his former partner's lawyer eventually pursued. My parents, terrified in the specific way parents get terrified when their child is facing something with actual legal weight, hired an expensive defense attorney, a man named Preston Voss, who required a substantial retainer up front, larger than my parents' modest savings could easily absorb. I found out how they solved that shortfall on a Sunday afternoon at my parents' kitchen table, in a conversation that lasted less than 4 minutes and reshaped the next decade of my life. My mother mentioned it almost as an aside, the way you'd mention having moved a piece of furniture, not the way you'd mention having made a decision that fundamentally altered someone else's future. She told me she'd been going through some of my old paperwork. I'd left a folder at their house months earlier, provisional patent documentation I hadn't yet moved to my own apartment because I'd been between leases, and had found what she described as the invention thing, and that a man she'd met through a friend of a friend, someone who apparently brokered early-stage IP for inventors without the resources to develop it themselves, had offered a modest lump sum for the rights to my provisional filing. Modest by the standards of what that idea would eventually become. Substantial enough, apparently, to cover most of Preston Voss's retainer. The lawyer needed a retainer, and your brother's situation is urgent, my mother said, already moving to pour more coffee. Already 3 sentences into the next topic before I'd fully processed the first one. I signed on your behalf. You understand. I did not understand. I asked her, slowly, to go back, to explain exactly what she meant by signed, and the picture that emerged over the next several minutes was worse than I'd initially registered. She had found my provisional patent paperwork, contacted the broker herself, and, because provisional applications can, under certain circumstances, be assigned by anyone with apparent authority over the inventor's affairs, especially if the paperwork wasn't airtight about ownership, which mine embarrassingly given. How early stage and informal my process still was not, had represented herself to the broker as authorized to act on my behalf, and had signed an assignment transferring my rights to the provisional filing in exchange for a check that had already, by that Sunday, been deposited into Preston Voss's retainer account. My father, sitting beside her, offered the sentence that has stayed lodged in my chest longer than almost anything else in this entire story. It was just an idea. You'll have more. I want to sit with that sentence for a moment because I think it contains the entire architecture of how my family understood me. To my father, a lifelong civil engineer who had spent 30 years building things that outlasted him, an idea that hadn't yet become a finished product was, apparently, disposable, replaceable, the way a rough sketch is replaceable, not understanding, or perhaps not wanting to understand, that the sketch was 2 years of my life, my actual intellectual property, the first thing I had ever built that was entirely mine. I closed my notebook. I remember this specifically, the physical gesture of it, closing the spiral-bound notebook that had traveled everywhere with me for 2 years, and I stood up from that kitchen table, and I did not raise my voice, and I did not ask them to undo what had already been done, because I understood, sitting there, that it had already been done, the check already cashed, the assignment already filed, the retainer already spent on a lawyer for a brother whose case, I suspected, even then was not going to end well regardless of how much money got thrown at it. I want to talk honestly about the months that followed because I think this is where the real vulnerability of the story lies, more than in any boardroom moment years later. I was 26 years old, and I had just watched 2 years of genuinely original work get sold out from under me for a fraction of what it would eventually be worth, by a parent who did not, even in the moment of confessing it, seem to register that she had done anything wrong. I drove home that night, and I did not cry immediately. That came 3 days later, alone in my apartment on a Wednesday, after I had spent 2 evenings trying and failing to find a legal avenue to contest the assignment, learning from a patent attorney I paid for an hour of consultation that because the provisional application hadn't yet named clear, exclusive inventorship documentation beyond my own informal notebooks, and because my mother had genuinely represented herself with some plausible appearance of authority to a broker who had no particular reason to interrogate a family member's claim closely, unwinding the transfer would require litigation I could not remotely afford, against a broker who had already, in turn, sold the rights onward to a larger industrial IP holding firm within weeks of acquiring them. The idea was gone. Not stolen in some dramatic, prosecutable sense, just gone through a specific combination of family carelessness and a system that offers very little protection to inventors who haven't yet learned to protect themselves. I cried, finally, on that Wednesday night, not the dramatic kind of crying, but the exhausted, disoriented kind, the kind that comes less from a single wound and more from realizing that the people who were supposed to protect what mattered to you didn't understand that it mattered at all. I called my closest friend from engineering school, Dev Patel. No relation to any Priya or Dev in any other story you may have heard, just a genuinely common enough name, who by then was working as a mechanical engineer in Austin and who had been, since our sophomore year, the person I called when something broke me open. Dev didn't try to fix it. He listened for over an hour, mostly in silence, and then he said something that has stayed with me since. You didn't lose the idea. You lost the paperwork. The idea is still in your head. Nobody can take that part. I want to be honest that it took me longer than I'd like to admit to actually believe him. I want to talk about my life during the years that followed because it existed fully in parallel to everything about the patent, and I think it matters that I tell you about it rather than letting the conflict consume the entire account. I stayed at Brannigan Fluid Systems for 3 more years after the assignment, continuing to build my career under Walter's mentorship, making senior engineer within that window on the strength of legitimate, recognized work that had nothing to do with the stolen idea. I started running a small evening class at a local community college teaching introductory mechanical design to career changers, something I picked up almost by accident when a friend of Walter's asked if I'd guest lecture once, and which became, over the following 6 years, one of the most quietly meaningful parts of my professional life. Watching adults in their 30s and 40s, often people who'd been told their whole lives they weren't technical, discover that they actually had real aptitude for this work felt like a specific kind of repair I didn't fully understand I needed until I was doing it. I got a dog, a rescue mutt named Ferris, during that period, largely because Dev told me, correctly, that I needed something in my apartment that depended on me showing up every single day, a small daily discipline that turned out to matter more than I expected. And I met my now husband, Julian, a high school shop teacher, ironically enough, at a hardware store, of all places, both of us reaching for the same obscure gauge of steel wire, an encounter so mundane it became, over the following decade, one of our favorite stories to tell at dinner parties. We married 4 years ago, in a small backyard ceremony, and we do not have children by choice, a decision we made together early and have never once regretted, though it's a decision that periodically still generates commentary from my mother that I've mostly learned to let pass through me rather than land. I did not, during any of these years, sit around plotting a comeback. I want that understood plainly. What I did, slowly, alongside all of that ordinary life, was return to the whiteboard. Specifically, the whiteboard at a coffee shop in Bloomfield called Arden Grounds, a place I'd been going to since college, where the owner, a woman named Frankie, who has known me for over a decade, eventually just let me claim the corner table permanently on weekday evenings because I was there so often working through design problems that she started referring to it, affectionately, as Renata's office. It was there, roughly 18 months after the assignment, that I began sketching what would eventually become my second patent, a genuinely distinct innovation, not a reworking of the stolen design, but an entirely new approach, this time to adaptive flow rate sensing in variable viscosity systems, a problem I'd become newly obsessed with after watching, at Brannigan, the same class of industrial customers struggle with a completely different bottleneck than the one my first design had addressed. I want to be precise about this, because I think it matters to the integrity of the story. My second patent was not a copy of the first, dressed up to evade the assignment. It was new work, born from continued expertise in the same industry, built with the specific, hard-won caution of someone who had learned, the expensive way, exactly how vulnerable an unprotected idea actually is. This time, I did everything differently. I filed the provisional application myself, under my own name exclusively with airtight documentation, the moment I had a design worth protecting, not 2 years in, the way I had before, but within months, even in its rougher early form, specifically to close the vulnerability that had cost me everything the first time. I told almost no one in my family anything about it. I told Dev and Julian and Walter, who by then had become not just a mentor but an actual friend, and who connected me, when I was ready to think about licensing rather than just internal use at Brannigan, to a boutique IP attorney named Sandra Kessler, who specialized in exactly the kind of independent inventor situation I was in, someone with real technical merit but no institutional backing, no venture funding, no family wealth behind her, just a genuinely good idea and a hard-earned unwillingness to let anyone near the paperwork before it was locked down. I left Brannigan 2 years later, once the full utility patent was granted, to license the technology independently rather than assign it to my employer, a decision that required some delicate negotiation with Walter and Brannigan's legal team about the boundary between what I developed on company time versus my own, a negotiation that, because of my meticulous documentation this time, resolved cleanly in my favor. I founded a small licensing entity, Meridian Flow IP, essentially just myself and Sandra as outside counsel for the first 2 years, and began the slow, unglamorous work of pitching the technology to industrial manufacturers who might license it into their own product lines. It took nearly 3 years of dead ends, rejected meetings, and one genuinely demoralizing near deal that collapsed at the final stage before the first real license landed, a mid-tier industrial firm willing to take a chance on unproven but well-documented technology from an independent inventor. Once the first license proved the technology out in real-world deployment, 2 more followed within 18 months, both with larger Fortune 500 manufacturers, and the valuation of the underlying portfolio began compounding in the way these things sometimes do once a technology proves itself functionally rather than just theoretically. Last quarter, an independent valuation commissioned, as part of a broader licensing negotiation, put the aggregate value of Meridian Flow's IP portfolio at $175 million. I want to be honest that I did not, during any of this, think much about the first patent, the stolen one. It had been sold, years earlier, by the original broker to a larger industrial IP holding company, and I had made a deliberate choice, early in my rebuilding, not to track what happened to it, because I understood that dwelling on it would only keep me tethered to the worst afternoon of my adult life instead of building past it. I did not know, until fairly recently, who currently held those rights, or what had become of the design in the years since. The reveal, when it finally came, arrived through the single most mundane mechanism imaginable, and I think that mundanity is actually the truest part of the whole story. A firm called Castellan Industrial Holdings, a large diversified IP holding company, reached out to Meridian Flow roughly 4 months ago about a potential partnership. They were interested in cross-licensing a portfolio of flow regulation patents they held, my second patent's technology complementing something in their existing book in a way that made commercial sense for both sides. Sandra handled the initial outreach on Meridian Flow's side, and I want to note that I did not, at first, connect Castellan to anything from my past at all. They're a large enough holding company that their name alone told me nothing. What happened next happened entirely outside my control, through a mistake that belonged to someone else's inbox, not mine. Castellan's business development director, a man I'd never met, sent an internal-facing email to his own team summarizing the potential partnership, including background research on Meridian Flow's founder, standard due diligence, and in that background research, apparently pulled from public patent records, he noted, almost as an incidental detail, that Castellan's own portfolio included an older patent, acquired years earlier through a chain of assignments originating with a provisional filing from a Renata Okafor that appeared, based on inventor records, to be an early, less refined predecessor technology to the very patent Meridian Flow was now proposing to cross-license. He CC'd that internal email, meant only for his own colleagues, to an old contact list that had apparently never been fully cleaned since an earlier, unrelated deal, A list that included, absurdly, unbelievably, my mother, whose email address had ended up on it years earlier, through some tangential connection I still don't fully understand. Possibly related to the original broker who'd first acquired my provisional filing and who may have, at some point, listed her as a point of contact given her role in the original assignment. My mother, who does not work in patents, who does not follow industrial IP news, who almost certainly did not understand most of what she was reading, opened an email addressed to a stranger's internal team, saw her own former daughter's maiden adjacent name attached to a patent record she recognized with a jolt I can only imagine, and forwarded it to me without comment. Just the raw email, no note, silence where an explanation should have been. I sat with that forwarded email for a long time before I opened the attached thread fully and understood what I was looking at, that the company now proposing to partner with me on my second, independently built patent was the very same company that, through a chain of sales stretching back 9 years, currently held the rights to my first, stolen one. My mother texted me 4 minutes later. 3 words. Is this? The sentence trailing off unfinished, as though even she couldn't complete it. I want to describe what I felt in that moment, because it wasn't triumph, and it wasn't the righteous vindication these stories are supposed to deliver. It was something far more disorienting, a kind of vertigo at watching the 2 timelines of my professional life, the one that got taken and the one I'd built to replace it, suddenly, accidentally, intersect through nothing more dramatic than a misdirected CC line. I didn't respond to my mother immediately. I sat with Julian that night and talked through it slowly, and what surfaced, underneath the vertigo, was something I hadn't expected, not rage, but a specific, clarifying grief. Because seeing Castellan's internal note about my predecessor technology made something concrete that I'd spent years keeping abstract. My first idea, the one from the notebook, had actually gone somewhere. It had been developed, presumably by someone else's engineering team, into something real enough that a company had held onto the rights for nearly a decade rather than letting the patent lapse. Somewhere out there was a version of the invention I'd sketched at 26, built by other hands, generating value I would never see a cent of, under a company's name that had no idea, until a stray CC line told them otherwise, that the original inventor was about to become their newest licensing partner. I called Sandra the next morning, and we handled the situation exactly the way the situation demanded, professionally, carefully, with full disclosure to Castellan's legal team about the history the moment it became clear they'd need to know, given that continuing the partnership discussion without acknowledging the connection would have been its own kind of dishonesty. Castellan, to their credit, handled it with more grace than I expected from a company that large. A senior IP counsel named Aaron Reyes called personally, acknowledged the strangeness of the situation, and, after an internal review, offered what amounted to a genuinely fair renegotiation, a modest retroactive royalty adjustment on the original patent, not a fortune, not anything close to what 9 years of full ownership would have generated, but a real acknowledgement, in dollars, of where the underlying technology had actually originated, alongside moving forward with a new cross-licensing partnership on my second patent, on terms I'd negotiated entirely on my own footing, years after anyone in my family had any say in what happened to my work. I called my mother back 3 days after her unfinished text, once I'd had time to actually decide what I wanted to say rather than reacting in the moment. I told her, plainly, what had happened, that the email she'd stumbled into wasn't a mistake on my end, that it was Castellan's own internal due diligence connecting a technology she'd sold away 9 years earlier to the technology I'd since built entirely without her. I told her that my second patent, the one now worth the bulk of that $175 million valuation, existed specifically because I'd learned, the expensive way, never again to let anyone near my work before it was locked down in my own name alone. My mother was quiet for a long time on the phone. When she finally spoke, she didn't apologize in the complete way I might have wanted years earlier at that kitchen table. What she said instead was, I didn't think it would ever be worth anything. If I'd known. And then she stopped herself, and I understood, hearing the sentence trail off exactly the way her text had, that she still, even now, was measuring the wrongness of what she'd done by the eventual dollar value of the idea rather than by the fact that it had never been hers to give away in the first place, worth anything or not. That's the detail I still can't get past, even now. Not that she didn't apologize fully, People rarely do, in my experience, when the apology would require them to fundamentally revise their understanding of themselves. It's that even her closest approach to remorse was still shaped entirely around the money, rather than around what it had actually meant to me to have that notebook closed for me by someone else's decision. I want to be honest about where things stand now because I don't think this story earns a clean ending, and I don't want to pretend it does. Teo lost his case. In the end, roughly a year after the retainer that consumed my patent, the charges weren't fully dropped, but the outcome was, by every account I've heard, worse than what a less expensive, less aggressive lawyer might have negotiated, which means the money spent on Preston Voss's retainer didn't even purchase the outcome my parents had been so certain justified taking my idea in the first place. Teo and I are not close. We speak maybe twice a year, careful, surface-level conversations that neither of us seems willing to push past into the actual history between us, though I don't believe he fully understood. Even now, the mechanics of what happened to my patent, I think he still largely experiences that period of his life as his own catastrophe rather than as something that happened at my expense too, and I've made a kind of peace with the fact that he may never fully see it the other way. My father has never once, in 9 years, revisited the sentence he said at that kitchen table. I don't know if he remembers saying it. I've never asked him to. I have, alongside all of this, a genuinely good life. Julian. Ferris the dog, now gray around the muzzle, my evening classes at the community college that I still teach even now, purely because I love it, not because I need the income anymore. Dev's still a phone call away after nearly 20 years. Walter, retired now, who I still take to lunch every few months because I owe him more than I think he'll ever fully let me acknowledge. I have Meridian Flow, a company that is entirely unambiguously mine, built the second time with every protection I didn't know to build the first time. I have a settlement from Castellan that will never total what 9 years of full ownership would have generated, and I have made peace, mostly, with the fact that it never will, because chasing that exact number would mean staying tethered forever to the version of myself who lost it. What I don't have, and don't expect to ever have, is a mother who understands that the wrongness of what she did was never really about the eventual dollar figure at all. What I don't have is the version of my 26-year-old self who got to watch her own first invention become whatever it eventually became, under her own name, on her own terms. I still have the original notebook. I kept it, even after the assignment, even though the idea inside it legally belonged to someone else for 9 years. I still, occasionally, open it, and I look at the sketches from a version of myself who hadn't yet learned how vulnerable an unprotected idea actually is, and I feel something that isn't quite grief, and isn't quite gratitude, some third thing I still don't have a clean word for. I think that third feeling, whatever it is probably the most honest thing I have to offer instead of an ending.